former governor Depri Alameshia of the oil-rich southern Nigerian state of Bayelsa was arrested at Heathrow, London on September 15, 2005 by officers from the Metropolitan Police, XCDCs, and was later released on bail pending further inquiries by investigators. He was returned on November 15, 2005, but he fled the country before that day. It was also reported that in 2008, the UK barred Senator Andy Uba from entering the country, having considered that his presence was not conducive to the public good, although the senator applied for a review of the decision to revoke his visa by the UK authorities. In 2012, former Governor James Ibori pleaded guilty to charges brought against him by the UK authorities. On May 9, 2016, Peter Clark, a retired detective constable with the UK Metropolitan Police, testified before a federal high court sitting in Abuja to the effect that the former governor of Plateau State, Joshua Dariye, was wanted in the United Kingdom for money laundering charges. And on Friday, 2nd October 2016, former Minister of Petroleum, Diziani Alinsi Madueke, was arrested in London on charges of money laundering. Certainly, Nigerians in Britain are used to having the leaders and compatriots paraded before British courts. Though the EKWEREMADUS case has nothing to do with fraud, notwithstanding, organ harvesting is a criminal offense in the UK under the Modern Slavery Act 2015. Now, how will the UK's experience of dealing with high-profile Nigerians arrested or wanted in the UK for some charges affect this case? How will this case impact on Ekweremadu's family, his associate political friends, and more importantly, Nigerians in Britain who have gone through this type of situation again, and again? Joining me live from London is Daniel Elumba. Daniel is a UK-based lawyer and a publisher of Elumba News. And my colleague Utibe Umaran, HIT senior correspondent who is in London to cover the trial of Senator Ekweremadu. They'll be joining me to look at what is happening and how far this case will go, both on the political, social, and of course on the legal angle. I'll be back after this break. Don't go away.
The trial of Senator Ekweremadu and his wife Beatrice is now formally before the Central Criminal Court in London, where it was transferred from the Oxbridge Magistrates Court, where the initial remand hearings took place. It is a long and tortuous road for Ekweremadu, who is physically not in court, but his wife Beatrice was, along with Obinna Betta, the medical doctor who was arrested recently for alleged conspiracy. The Ekweremadus are accused of breaching the Modern Slavery Act, a legislation passed in 2015. Section 1 of the law prohibits slavery, servitude, forced compulsory behavior, while Section 2 of the Act prohibits arranging and facilitating travel of another person with a view to exploitation. The Act further defines exploitation to include removal of organs. This is what the British prosecutor is pinning on the Ekweremadus. Their travails began after one David Wamini presented himself to British authorities on the claim that he was kept under conditions of slavery after refusing to submit himself for a clinical procedure requiring him to donate his kidney to Ekweremadu's sick daughter who needed a transplant. David was taken from Nigeria to the UK for the procedure, which was scheduled to take place at the Royal Free Hospital. He had earlier lied to British Metropolitan Police that he was 15 years old. After documents emerged, including his passport details and other biodata filled in his documents in Nigeria, British authorities admitted he is actually 21 years old. But the prosecutor, Tim Probert Wood, said that the new fact in his age changes nothing as far as the charge against the Ekweremadus are concerned. Lawyer for the Ekweremadus, Martin Hicks, had earlier insisted that his clients are innocent and that there was no exploitation or intent towards exploitation. The pre-hearing commenced on Thursday before the Central Criminal Court, Old Bailey's. The parties agreed for a trial preparation hearing on October the 31st, 2022. Trial preparation is a process of streamlining all materials needed for trial, the facts of the case, number of witnesses to be called, and other material information needed to ensure the trial is not delayed once it starts. When asked whether he intends to bring in more arrests, Prosecution counsel said none is planned for now.
The case against Ekweremadu is getting more complex as the proceedings unfolds, but the court is much more interested in tidying up with the intricate details of the charge and moving ahead with trial. The prosecution strongly believes it is a tight case based on what its investigations have revealed, the details of the investigation of which it is keeping tightly under wraps until trial.
In court for Thursday's hearing were members of the Nigerian mission in the UK and some members of the National Assembly.
It's a hard time, and people should abstain from trouble. But most importantly, we should focus on rebuilding Nigeria, get Nigeria going, and ensure that things are done properly.
Ekweremadu is to remain in custody until the 31st of October 2022. It is not clear whether his lawyer will initiate a fresh bail application for him, but AIT gathered that the prosecution intends to maintain his opposition to it on grounds that, based on his status, he presents a flight risk if admitted to bail.
All right, that report was filed by Utibe Umarin, AIT senior correspondent covering the trial in London. He's joining us still in London live. Utibe, thank you for taking the time to join us now. Thank God the weather is still about the same thing here in Nigeria. It's just that you've got a longer day out there in London. It's still bright even as of 8 p.m. Great. Utibe, I'm not going to ask you about the legal implication. We don't know what this will be, but let's go to the social angle of this case. In my intro, I spoke about the prayer in 2005. I spoke about Andy Uba in 2008. I spoke about Ibori pleading guilty in 2016, Diziani in 2015. This has happened again and again. So this case will probably not be new to Nigerians living in Britain, how they have seen their leaders and compatriots paraded before British courts. Tell me, what is the mood there in the court yesterday among Nigerians that have come to witness the hearing? What is the mood there? What was it like yesterday?
Well, it was a somber mood today here in London at the hearing of the case. On Thursday, there were quite a number of sympathizers, of course. From that report, you could see some senators who came from Nigeria and some members of the House of Representatives who were here to, solidarize with the Ekweremadus on this very difficult time in which they found themselves. And you also had some Nigerians residents here in the UK as well, who also came around to witness the proceedings. And of course, you always find people too who are angry about the big man in Nigeria, in quotes, the big man who they strongly feel ain't doing enough to improve the socio-economic well-being of Nigeria and Nigerians. And some of those guys are residents here. They've been residents in the UK for so long. A lot of them are very frustrated about the news they hear happening in the country. They're not happy and things are not working. And we had some persons with placards and posters carrying non-complimentary messages against Ekweremadu and, of course, Nigeria as well. And, I mean, you can't really blame them much. They have justified reasons to feel the way they feel. They feel this is an opportunity for them to vent as well. Having Ekweremadu, who is considered one of the political elites in Nigeria, has been in the National Assembly since 2003. He's been Deputy Senate President for 3 terms. That's 12 years. And they feel if people like him were able to put the infrastructure in place, using their position and influence and power to ensure that the executive, whether the federal or the state level, did the needful, then he wouldn't have to come this far to bring his daughter over here, and which has eventually ended up putting himself in this kind of trouble, which he eventually finds himself right now. So it's a mixed tale of emotions here. People, mainly who were in court, who came to sympathize with him, and there's still some few people, not just those who were present in court, but also those you find their messages online on social media and saying, well, that serves him right. So, of course, you really can't hold it against them. They're entitled to their views or their opinion on matters such as this.
All right, Otibe, I'm going to come back to you. Yes, thank you, Otibe. Let me quickly go to Daniel, a lawyer and the publisher of Elumba News. Daniel, thank you for your time. I mean, you've been in London quite for some time now. You've gone through all these criminal charges being brought through high-profile Nigerians, starting from the days of Alameshia down to Dijani, Bori, and to Adi. All these people, we've gone through all these, plus and including some of the small Nigerian elements in the UK appearing before UK courts every day. What does this case say about Nigeria? How do the UK government and your friends in the UK who are non-African, who are not Nigerians, seeing another criminal charge being brought against a high-profile Nigerian citizen? Daniel.
Well, first, let me first of all say that what I found interesting is in the manner this Ekweremadu case is being reported in the media. The media harps about organ transplant and exploitation. But when we look at the case carefully, it is interesting that the UK police is saying that Ekweremadu is not being charged under the Human Tissue Act of 2004. It is being charged under the Modern Slavery Act of 2015. And emphasis is being laid on being trafficked for exploitation. So that is one thing people have to take into consideration as to what the issue in this case really is. Another thing I want to point out is the issue of diplomatic immunity that people have talked about. It's been revealed that Ekweremadu traveled on a diplomatic passport. So I think eventually the trial will have to proceed on whether Ekweremadu will have to be sent back to Nigeria to be tried, or whether he should rightfully be tried in the UK under the Geneva Convention. Another thing worthy of note, worthy of note in this trial is the question of how Nigerians in the UK perceive the whole trial. A lot of people have seen on the video are angry that the rich men, the Nigerian super rich, travel to UK for medical treatment while not doing anything to improve medical facilities in Nigeria. The 15% budgetary allocation that should be devoted to the healthcare has been observed more in the breach. So that is another issue that many Nigerians are angry about. Now, if we now move to the issue of the circumstances under which Ekweremadu was arrested, one thing I have to point out is the issue of penalty. The Modern Slavery Act points out that a person convicted under that Modern Slavery Act, sections 1 and 2, is liable to life imprisonment for life. Whereas a person jailed on summary conviction can be jailed only for 12 months. So while Ekweremadu have not pleaded, no plea has been taken. But I understand there is indication to say that they may plead not guilty. And so the question is, why would they allow this trial to go ahead if the case is so tight? If indicating they will plead not guilty, that means they feel they have a very strong defense to the trial. The Nigerians have to note a major fundamental difference between prosecution in the UK and prosecution in Nigeria. In the UK, the police can only investigate crimes. They don't prosecute. So they refer it to the Crown Prosecution Service. So, and for a Crown Prosecution Service in this type of issue to bring this matter to a trial, must have to be certain for at least maybe 60 to 70% conviction, especially where, in a case where it involved a very high-profile politician from Nigeria, the Crown Prosecution Service will not recommend this case for trial without reference to the Attorney General, the Attorney General of the UK government, who must have approved this trial to go ahead because of his political nature. So it's very significant that the UK government is allowing this trial to go ahead. I think Ekweremadu have not been granted bail, and this matter have been adjourned for hearing pre-trial management hearing in October, and then the main hearing again for next year. I don't know whether you allow me to now talk about how much time we have to talk about the social and
Daniel, I'm afraid we do not really. Daniel,
is that what you want me to do now?
Daniel, we do not have much time today. But listen, we're coming back next week. By next week, hopefully, my colleague in the UK would have returned to Nigeria. Then he will be with me in the studio to share his experience. Then you'll be back next week to do more justice to some of these issues you have raised. But let me ask you one more question before I let you go. Quickly talk on the issue of him being arrested on diplomatic passport. Will that be a defense that, look, having been arrested, does criminal charge, does diplomatic immunity go as a cover for a criminal charge in this matter? Would the citing of the Geneva Code be a covering, a protection?
Okay, not necessarily. Diplomatic immunity is not a defense to a criminal charge. However, the UK government may opt to have Ekweremadu be repatriated to Nigeria under the Geneva Convention for the trial to take place in Nigeria. Or on the other hand, the Nigerian government may have to waive the immunity and allow Ekweremadu to be tried in the UK. However, it is for the authorities to confirm what type of diplomatic cover Ekweremadu has, because diplomatic immunity has several levels. You have sovereign immunity, which is, if it comes under sovereign immunity, then they cannot try him in Nigeria. For instance, the head of state, Nigerian president, or a governor, I think. So that type of immunity only extends to a certain degree of Nigerians. But if the type of immunity he has is a lower cadre of diplomatic immunity, then of course, the UK government decides on the gravity of the crime, they decide to try him in the UK. But we have to wait actually to see, because we haven't have the charges read. So until we see the full details of the charge against Ekweremadu, we'll be able to speak more on these issues.
All right. Thank you, Daniel. Let me go to Utibe. Utibe, I mean, this case appears to be dragging. And look, when this man was first arrested, he's been to court 4 times now. Now he's going in October. Why do you? I don't know if you got feelers out there. Why is the UK court dragging this issue this far and this long? Why is it taking his time, yet not giving this man the privilege of being granted bail? He's coming back in October. They could have moved this till 1 week or 3 days. Then after October again in 2023. Tell us, what are you hearing? What do you hear? Why?
Tunde, I think it all has to do with the status of the Ekweremadu himself. He is considered as a person of influence in Nigeria, and being a citizen of Nigeria, not a citizen of the UK. I think the British authorities think that granting him bail might be prejudicial, because he may possibly jump bail, and that's why even the bail granted on very, very stringent conditions. You couldn't understand why they had to consider bail for his wife, probably on humanitarian ground, because of course, remember that they have a sick daughter to tend to, so there must be one of the parents available to take care of the sick daughter. And that's probably one of the reasons why they considered admitting her to bail. She was in court yesterday during the hearing. So Ekweremadus might be a bit more complex, and I think that's why the lawyers, the prosecution, are trying to see how they can move the case forward as soon as possible. Remember, the arrest was made on June 23, and now we're talking about pre-trial sessions already. By October 31, when the pre-trial preparation of trial would have been concluded, then we'll know exactly when the trial would commence. And I do not think that it's particularly slow. I mean, when you compare it to jurisdictions such as Nigeria, where criminal cases can drag for on and on and on, if not for the recent convention of that administration in 2015. So I think it's moving on course in line with what British judicial processes and procedures are. to ensure that as soon as they complete the trial, pre-trial preparations, they would go straight to trial. I think, let me just quickly mention, as a corollary to what Alumba said, because he talked about him not being charged under the Human Tissue Act of 2002. But if you look at the charge Modern Slavery Act 2015, Section 1, 2, and 4. Section 2 in particular makes reference to the Human Tissue Act, and which includes illegal removal of human organs. In anywhere in the Human Tissue Act, the only provision where it provides for removal of Human Tissue Act is where consent is made. And for you to remove that, then the consent would have been made prior to the person dying. It's a deceased person that you can actually remove a human tissue, any part of the organ of the body, from the person. And even at that, the consent is so strict that if it was the consent of the individual before he died, that my part, so and so organ of my body must be removed for so and so purpose. You must strictly comply with that purpose. If you deviate from that purpose, then you've violated the principle of consent which the person had given for his or her part to be used. So the Modern Slavery Act 2015, which is what EKWEREMADU is likely going to be charged with, because it contains exploitation as well, and exploitation is defined under the Act, has elements of removal of human body parts, contains all of that. And that's why I said earlier, it is a complex case, and it's going to take, smart lawyers to really get EKWEREMADU out of this situation, which is right now.
Very unfortunate. Thank you so much, Utibe. Daniel, I'm afraid this is how far I can go, but next week, Friday, I'm going to have a comeback here. We will look at the social angle to this problem, some of the implications on you as a Nigerian who's seen this over and over again, and then we'll talk a bit on the implication to his associates, his family, and the influence of previous charges that have been brought against high-profile Nigerians in the UK. Probably some of these reasons the UK government is saying, look, learning from experience, the pre-alarmia issue, we might not be willing to grant you a bail on this condition because you are a man of influence. This issue we'll take a look at next week, Friday. Daniel, we do hope you will make time to join us again next week, Friday, because we need to crack this down and look at the social implication of what is happening in the United Kingdom. Why high-profile Nigerians most often get into trouble when they get to the UK, things normally they can get away with here in Nigeria. Daniel, thank you so much for your time on the program. You raised a lot of issues. We'll come back to deal with them next week, Friday. Utibe, thank you for your time. I think I shall allow you go back to your hotel now and have some quiz. You've been out there all day. Thank you guys for your time with me on the show today. Daniel, thanks a lot. Utibe, thank you so much. This is how far I can go on the program today. We've been looking at the pain and this trauma of a parent trying to save his daughter in the United Kingdom, getting into some legal issue in that part of the country. My name is Tunde Alabi. Stay out of trouble and enjoy your weekend. Bye.